Welcome to my High B podcast, where we'll dive into a fascinating intellectual property battle in Nigeria entertainment industry, the Domitilla trademark dispute. This case pits a renowned Nollywood producer against an actress over the ownership of a trademark tied to a blockbuster movie, raising critical questions about creativity, ownership, and law. In 1996, Ejiro, a celebrated Nigerian filmmaker, produced Domitilla, a movie about a young woman surviving as a prostitute in Lagos, starring Njemanze as the title character, alongside stars like Kit Henshaw and the late Hada Hame. The film became a cultural milestone with a sequel, Domitilla 2, released in 1999. Njemanze's stellar performance made us synonymous with the name Domitilla. Fast forward to 2020, Ejiro announced Domitilla, The Revolt, set for release in 2023 on Netflix. He approached Njemanze for supporting role, but talks broke down over payment disputes. Then comes the bombshell. Njemanze sent Ejiro a cease and desist letter claiming the revolt infringed her trademark, Domitilla hand device, registered in September 2020 under Class 41 Entertainment Services. Ejiro fired back, petitioning the Trademarks Tribunal to cancel her registration, arguing he created the Domitilla brand and that Njemanze acted in bad faith. Meanwhile, Njemanze filed a lawsuit in March 2023 at the Federal High Court in Lagos, seeking 50 million naira in damages and an injunction to stop the reboot production, accusing Ejiro and co-producers Film One Entertainment and others of trademark infringement. Still in 2025, Njemanze escalated the fight, filing a new suit in Abuja to challenge the tribunal's 2020 ruling against her. Let's break down the key issue in this saga. Njemanze argues she is the rightful owner, having registered the trademark in 2020 and built goodwill, as fans still call her Domitilla. Ejiro claims prior use in 1996 asserted he created the Domitilla story and character, and Njemanze's registration was opportunistic, timed with reboot talks. My take on the Ejiro has the stronger claims. He created the Domitilla story and character, and Njemanze's fame has Domitilla stemmed from his films. Registering a trademark during the reboot negotiation feels like a strategic move, not a genuine claim of ownership. Given a consideration to forced to register versus forced to use popping up in this saga, Njemanze insists trademark law favors the forced to register. Ejiro relies on common law arguing prior use establishes proprietorship. Given the evidence of bad faith, prior use should prevail here. Nigeria's Trademark Act and global IP law norms like the TRIPS Agreement protect established users against deceptive registration. And on the course of jurisdiction and timing, Njemanze argued Ejiro's 2023 petition was late as the opposition period for her trademark ended in December 2021. She claims the tribunal lacked jurisdiction. Timing proves a valid point, but the tribunal authority passed Section 38(1) Trademark Act to correct errors, override strict deadlines when bad faith is clear. On copyright versus trademark conflicts, Ejiro owns the copyright to Domitilla films, but trademark protect names. It begs the question then, should the producer or actress who embodied the character own the trademark? Copyright and trademark serve different purposes, but the producer role as the creative originator should weigh heavier. Njemanze's association with the name doesn't justify claiming it as her own. Let's give a consideration to the arbiters' opinions. The Trademark Tribunal on February 4, 2023, via its registrar Shafiu Adamu Yari, ruled that Njemanze was not the true proprietor of Domitilla. The tribunal found that Njemanze's only evidence was the registry acceptance letter insufficient for proprietorship. Citing the common law, proprietorship depends on prior, not forced registration. Ejiro's use since the 1996 trumped Njemanze's 2020 filing. Njemanze acted in bad faith, knowing Ejiro created the brand, yet registering it during reboot talks. Under Section 18.7 and 22.1 of the registration Trademark Act rather, the tribunal consider application deemed an error. What is the conformity of this decision with IP law? The tribunal ruling aligns with Nigeria's Trademark Act and TRIPS agreement, which protect prior users and allow correction of erroneous registration. The bad faith finding is supported by Njemanze's timing and knowledge of Ejiro's brand. However, Njemanze's appeal raises valid procedural concerns about the tribunal bypassing the opposition deadline. Though I agree, I do support the tribunal's decision as Ejiro's prior use and creative ownership outweigh Njemanze's registration. A failure to appear in Lagos case which weakens opposition. Adequacy of Nigerian IP law in this regard. Nigerian IP framework, Trademark Act and Copyright Act 2022 handles this case reasonably, but has gaps. We can refer to strength as the Trademark Act allows error correction, Section 18.7 and Section 22.1, enabling the tribunal to revoke Njemanze's trademark. Section 23 supports unregistered trademarks via passing off, protecting Ejiro prior use. TRIPS compliance ensures global standard. The weakness this poses is that there are no clear link between copyright and trademark, and this creates ambiguity. Should actors claim corrupt names, the strict 2-month opposition period risks penalizing creators who miss deadlines. My recommendations would be there needs to be added provisions linking copyright and trademarks, like we have the Chioma 2020's trademark company name rules. Mandate actor producers contract to clarify IP rights. Timely trademark registration needs to be promoted to avoid disputes. This case shows Nigeria's IP laws are functional but need refinement to address creator performance conflict. To wrap up on this, the Domitilla's case is a wake-up call for Nigeria's creative industry to prioritize IP protection. While the tribunal's ruling was just, it exposes gaps in the legal framework that need addressing to better balance the rights of creators, like Ejiro. Creators must act swiftly as well to register trademarks, and actors like Njemanze should ensure their claims are grounded in good faith. What do you think about this case? Should actors have right to character names they popularize, or should creators retain full control? Share your thoughts in the comments. Thank you for listening.